Obliged.
Now we see what he does. Your submissions are intact before we get confused, so we reduced it in writing.
I'm sure he'll only elaborate and
There is a-
clarify.
But the other side, main contention is a presidential order and followed by full bench. Two contention. If I convince your lordship there's a presidential order is no application, and inter alia full bench is also no application.
Now we see what he does.
My submission is
Your submissions are
President is
intact
not
before we
your
get confused, so we
submission, then
reduced it in
Mr.
writing.
the
I'm sure he'll only elaborate and clarify.
Submission, you know
But the other
that
side
we have,
main
when
contention
you
is
began
for
the
a
argument,
presidential
we
order.
requested you to give
And
your
followed by full
proposition,
bench.
just to elaborate. First proposition.
Two contentions. If I convince your lordship there's a presidential order is no application.
No, we-
I will say,
No,
inter
no.
alia
So-
full bench is also no application.
Now
Just
we
like
see
this,
what
we
he does.
put it
To
to
Mr.
my
Reddy
submission
also, for
is-
sake your
of
submissions are
curiosity,
intact.
I
We
am
are
curious
we
to
get
know what
confused,
we-
so
in
we
addition, you
reduced
have
it in
to-
writing.
The
I'm sure he'll only
president-
elaborate and
Submission,
clarify.
is not issued.
you know
But the other
that
side,
we
a presidential notification regulating the admissions in educational institutions. After 2/6/2014,
regulating admission
in a state-controlled education, the educational institutions,
in educational institutions.
in the two states, in successor states.
In any case, for state of Telangana, we are concerned.
They may interpret the 1874, 74
Was either the state of Telangana
successor Andhra Pradesh. Because I dealt with the matter as an advocate general.
That's why.
And 2014 to 2017.
No, we were told that one of the GOs was issued when you were advocate general.
I have settled one. I've gone through it and I have settled one.
No, that's what my brother shared with me, that the one of the GOs to which you are referring was issued when you were advocate general of the state.
All the GOs, but the first 3 years my work is only that.
So first submission, this is second one.
The second one, the first submission, there is no presidential order issued.
Okay, second.
The second submission, well, the presidential order issued in the 1974, 50 years back.
It does not apply. That you told does not apply after 2/6/2014.
If a non-president issues any notification, pardon, it is only state-controlled institutions. If a non-president issues any presidential order, in terms of Article 371D, the president is only competent to issue in respect of state-controlled institutions.
No, that is may not be necessary for us to determine what is the
The present,
our
the present rules, one
Mr. This like this can't go on right now. Mr. Rao will not argue. He has concluded you are replying to his submissions. Don't make out a new case. Then we will have to give. He has not argued that president has power to issue in respect of all institutions.
the present rules were issued is not only state-controlled institutions and private institutions. I will.
Mr. Rao.
But then, my Your Worship, 371 email. One.
Mr. Senior, Mr. Prabhakar Rao, in arguing, he did not put it on that ground.
I'm only glad to say.
No, what we are requesting, Mr. Reddy, is that your scope is only confined to meeting the submissions of Mr. Rao. Don't start re-arguing the case, then again it will never end. Then he has to be given an opportunity, then you will rejoin the. He has put it very briefly, you have heard him saying.
I'm trying to within 10 minutes. I will not go into it. But I wanted to convince you the presidential order, no application, so that I'm saying. So these are my points, but I will think it.
These are the 2 points, right? 3, we will not go into it. We are telling you at the instance, we will record it, but we will not go into it because This is not what is argued by Mr. Rao. Correct, Mr. Rao? You did not argue that presidential order can be issued in respect of all other universities other than state-owned institution. You did not say, right?
Section 95
You
of
only argued that it is, these rules are in perimeteria
Yes,
with
but-
presidential order. And therefore,
Section 95 of Reorganization Act will not govern this.
Yes, sir, that's what I'm coming right. It's about section 95 of the Reorganization Act.
you read it.
All right. No, section 95.
What? Section 95, Madam, Reorganization Act.
Before taking about section 95, I request for 371D of the Constitution. 371.
Constitution. That validity of 371D has already been upheld by Supreme Court and nobody is challenging here in the petition. You are not challenged.
Two Roman 3. 2 Roman 3. 371D. Then I request you, you'll also kindly see the present. 397, and is report 95.
So you are not seeking admission to state-owned institutions.
Why the present?
No, we are asking like a query. You are not seeking admission against any state-owned institution.
What we are seeking.
Okay? Oh.
But you also got 95, section 95.
Yes.
Section 95 of the application. Equal opportunities.
Oh, 1 minute. Yes,
Yes.
95.
95. Equal opportunities for quality of higher education to all students. In order to ensure equal opportunity for quality of higher education to all students of successor state, existing admission quotas, but only quotas. What is the quota? 70. In government or private or aided or unaided institutions of higher technical and medical education. But protection has been granted in section 90, not only government institutions, all private and other educational institutions. The president can only issue in governmental institutions. So therefore, our rules you also can say, coming to our rules for 114, now the issue. Thank you. Thank you. But 114, page of
Which?
18. Oh, my first petition.
Yes, 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 we have got.
You have also kindly said, proposal submitted by so and so. Non-minority medical colleges, yes, private, non-minority medical colleges, private minority medical college, and private non-minority dental college. These rules not only government and private college. So that this GO is in accordance with section 91 of the reorganization act. And on the face of it expressly, the GO was not issued under Article 371D of the Presidential Order.
That he has told.
The Presidential Order. Presidential. Not issued under Presidential Order. Therefore, what are the quotas? The question is a quota. 97, 95 contemplates protection of quota. Quota says you are absolute. The government paper quota. But the government papers, the university papers.
Which page?
Take it. The control order, they page 15 minutes. Page 19, section 6, page 19. Page 19, paragraph 3, paragraph 6. Section 6, it is not proper. Presidential order, say paragraph 6. So, admission to the 85% of available seats in every post study by statewide university or statewide education institution shall be reserved in favor of local candidate allocated among the local candidates in relation to the local specified in subparagraph 1 of subparagraph 2 of subparagraph 3 of paragraph 3, the ratio that is these are quotas. 42 Telangana, 36 Andhra, 22 Rayalaseema.
Just now, Mr. Reddy has argued, Mr. Mayur Reddy has argued that this, which you have also said, that the rules have been issued, impugned rules have been issued under the Act. Act is enacted under entry 25 of list 3. It has nothing to do with the presidential order. On one hand, you are arguing this that presidential order has nothing to do with the facts of the case, and you are relying on section para 6 of the presidential order. This can go together, we were wondering.
I'm saying in 95, these quotas only. And what I'm submitting, the presidential order is not protected. The Reorganization Act 95 has not protected the presidential order. Only quotas specified in the presidential order. The president, the state
That's all right. Section 95, this you did.
95 has only protected the quotas described in the existing quotas of the state.
Described in presidential order.
The presidential
Universities which were existing as a.
So what? This, what is submission is that section 95 only protects the quota prescribed in para 6 of the presidential order.
And applies only to universities which are there.
Applies to existing universities. Universities existing on
2/6. That we have already used that the other day we allowed them to declare it. So when you said that was the country.
But what I am submitting, right, the section 95 did not say. But the bank, but section 95 did not say. That
Mr. Only thing is, Mr. Senior Counsel, it's always a pleasure to hear, but this is, scope is confined. To what? This is not a fresh argument, right? You are arguing for fresh.
Giving reply, what he says the presidential order will apply. Presidential order will not apply, only quotas are protected.
That's what you are arguing. Then what else?
So, but this aspect was also dealt by the full bench. But your lordship, the full bench. And intermediate at the same time, a 646 GO was issued under para 6 of the presidential order. Paragraph 8, paragraph 8. Paragraph 8. Paragraph. That is only not applicable. Paragraph 8 of the presidential order.
Zero
646.
This is 21 of what? Vacate petition. Issue.
Therefore, on 646 also no application. When presidential order is entire presidential order is no application except protection of quota. That was dealt by for your assist. The full bench required full bench.
If we hold that the reference need not be made to presidential order, are we required to go into this issue? If we hold, we have to come to a conclusion. We are only suggesting. If we say that GO 114,
Please.
we accept your contention is not issued under presidential order, then are we required to examine this aspect?
I am saying by that.
No, that is true. But you see, but we are not. But what I am saying is, if we are with you, assuming we are with you, we are not with Mr. Rao on that aspect, that this GO 114 is not issued in terms of presidential order. Therefore, the reliance placed by them on presidential order is not correct. Are we still required to go into this issue? No, that is true. But that's why I'm saying if we are, we have understood, that is why the full bench also places reliance on Article 371 B And therefore, we have examined that Mr. Mayur has already elaborately dealt with it. Both the issues we have considered. If any further new point, like you said, the GO, the 646 is under clause 8, we have noted.
For my submission, there is no privilege. There is the full bench has relied upon, considered by the full bench, laid out the law. Therefore, full bench has no obligation.
That we have noted. Not only the full bench, the subsequent two decisions, one of this court and one of the AP High Court have also no relevance. That we have noted, yes.
Then once the last time consider the rules, under the rule, the legal action is the same.
Yes, yes, principle of reading down has to be applied.
The legal action.
You have already argued that. You need not repeat. You are relying on Meenakshi and then Bombay High Court. And you are saying that it has to be read down in context of children whose parents are members of All India. We remember, Mr. Your submission, not that forgotten.
Right? State government rule, the rule says that. It's certainly by candidate comes to para over 1, the 2 years they exempted, alternatively paras. 7 years. That by what was the
It is like putting the cart before the horse or horse before the cat.
You are not sure that we have understood or not. So therefore this lighter side, Mr. Kavi, at least you can smile, right? There's nothing serious. Same thing you just now you said.
That's why I said if it had come, that would have saved the
time.
trouble of writing down.
You have got it, Mr. Rao. Yeah, Hurry, give it to him first before passing it on.
simultaneous.
Simultaneously, correct. Yeah.
This is nice.
Thank
I'm
you.
very grateful.
Thank you.
Grateful.
Right.
Kindly pardon me for taking leave of this honorable court. My friend is saying the presidential order has no application, GO 646 has no application, and also the full bench has no application. That should be kindly see the rules, rule 3 will adjust. For my benefit adjust. But it is not under challenge. Well, the eligibility criteria,
They are required to satisfy under order.
but this is not under challenge, that's the only reason.
Which page?
Rule 3, page 9. Page 19 of my senior
What?
counsel's book.
19. This.
Eligibility.
3A. 3A is not under.
Local, non-local status requirement has laid down to the president, the Andhra Pradesh Education Institutions Regulation of Admission 1974 as amended GOMS
They have to
GOP number
satisfy.
646.
That is the regard, quota.
That is with regard to quotas which the honorable senior has placed before your lord.
All right.
Further, my lord,
Power is at the beginning.
That's it, Mr. Rao.
further, my lord, the facts in full bench. Also, my lord, a candidate has studied in Guntur first to 10th class, 2 years in Gujarat.
You read it?
Same thing is all the another candidates, same thing. They did not study 7 years of education.
But this is a different, right? Here is a candidate who studied up to 10th in Hyderabad and attended online in Kota. That is not covered by full bench. Because full bench when it dealt with
Yes.
lighter side, Mr.
That is also.
Online classes were not contemplated when 2001 judgment was delivered by full
When
bench.
that case comes, I will make my submission.
No, everything comes and goes. It's closed now.
But my submission was on that case, and my submission is
No, all these cases are being closed, Mister. For now, reserved for delivery of judgment.
I filed my counter in that case. In that case, the study Study 5 years.
That we have understood.
Resident.
We have understood that petitioner in that case is not entitled, even though she may have resided, but she was studying in an institution recognized by you.
That's all. That's all.
That we have, so far we have reason to believe that our memory is good, so at this point of time in life also.
The senior counsels are powerful in arguing the matter, therefore I just submitted my achievement.
All right. Yeah.
He may be senior by designation. They are the mighty state. One individual against.
I don't, we don't know whether, but Mr. Rao is also mighty person.
The state under 12.
State under 12. Yes. Yes, please. Thank you, Mr. Reddy. It was pleasure. Yes, Mr. Reddy, pleasure hearing all of you. Yes. Mark everybody's presence. Reserved for delivery of 1 minute. Reserved for delivery of judgment. Which cases? These cases of number we have taken, right? So what item number? One minute, madam. No.
Other batch.
Batch. What are you? 41 to 41 to 50. 50.
Milord, they are 41 to 52, Milord. 53 to 56 is another matter.
No. We are reserving only 41 to 50.
Very well.
Huh?
Milord, I am in 51.
51 is different.
Submissions, Milord.
51 and
51, I am in 51, Milord.
51 is that.
Online, Rajasthan quota, Milord.
You said he has told no.
Milord, I have to make my submissions, Milord. That is the reason
Make submission differently. We will not hear you now. This is, madam,
Milord,
cruel to the court. Being not reason, just a minute, not being reasonable to the court when these people are arguing.
Milord, I am waiting.
Just a
to be
minute.
given, Milord.
You don't be there and then say that my case is different.
I am there, Milord. I am only waiting for my turn, Milord. I was,
This is, Mr. Rao has argued, right? Just,
yes, Milord. Yeah. I have to make my reply, Milord, to his argument.
all right, we will exclude your case. Sit down.
Yes,
First, sit down.
51.
Sit down, please. Nothing is being done in your case. It will be called. Please
Yes.
sit down. Item 41 to 50. Arguments heard reserved for delivery of judgment. What are 52 you are saying, Mr.?
Milord, 53 to 56, Milord.
No, different. That is NCC quota, Mr.
Yes. That's what I.
52 is what?
That means cap.
Cap. The cap is also different.
Cap is different.
He has got special instructions in that case, Mr. Rao. 50. Rejoinder, reserved for delivery of judgment. Then in that separate page, right? Learn it. Learn it, senior counsel. For our memory,
Yes,
we are
sir.
what Mr. Reddy, senior counsel, has argued.
Yes.
Just
Sit down, sit down. This is reserved. Learn it, senior counsel for
petitioners who are before the court, everybody else results are declared. Petitioners may also be declared. It appears as if we are being punished for being in court.
We have considered, we have kept it hold as ordered by the San.
But everybody else,
Result declared?
No. For these candidates,
No, generally
they
declared.
will declare.
Declared. So,
we should also be declared. Why we are being withheld?
That is your lordship that.
15%, considering that the 15%.
at least consider against
Yes,
15% quota.
Consider lordship.
No, but you have withheld their results.
We are withheld.
Lordship, may pleased to say, that your lordship's order to consider their cases, we considered, kept them in hold.
Sealed cover. If Mr. Rao alone knows what is your fate. This file, we don't know.
No, if no result was declared, we would have no case. But if results are declared, why?
That's what we are asking. That's Mr. Rao, you had considered para 11 of this thing.
Yes. We will consider that.
Consider it.
Yes.
So,
Para 11, they will consider if you are eligible
para 11 is only for 15.
15%.
For
Ah.
people. But for the
And
rest,
rest is
yes,
sub judice.
yes. So,
That's the difficulty.
yes,
That's why we are doing all this exercise, right?
yes,
For our memory, we are writing here so that we may not miss
yes.
everything, updating ourselves with
Yes.
each passing moment.
Very good.
So we'll try to do it as fast as possible.
Yes. Deeply obliged. Deep.
But Mr. 15% quota you will consider, right? 15% quota as per para 11 you will consider
Yes, sir.
petitioners.
Sir, consider the case of my senior, my counsel, Lord, she got the seat under 15%. The Rajasthan case.
Then end of the matter.
Milord, petitioner is entitled. Is
No, 1 minute. We first here, she wants to argue the case. You're not interested in seat argument. So 1 minute, madam, 1 minute. Your colleague is unable to point out that her case is entirely different and under cap quota. So we want to deal with her first.
Yes.
1 minute. We will take up your case.
I'll wait.
Still 25, 30, 35 minutes. We will sit. What is 52? What is cap? This is different. Cap quota is what?
Cap quota, my lord. The petitioner,
1 minute, Mr. Rao, lighter side. So you have declared you have said that item number petitioner in serial number 51 has qualified. So, and you have not said anything about others. So inference is that others have not qualified. This is lighter side. Inference we can draw, and the Mr. Reddy must have drawn is that other petitioners are not qualified for the 15% quota, even though you would let them know at a later point of time. Okay. We don't know. You may be in for a surprise also. No, Mr. Rao, should you not inform us? So in that case, those petitions can be disposed of by us. All other candidates may not be interested in arguing like Madam 51. They will, if you get in 15% quota, what?
Yes, madam. Out of the two matters I've argued, one is under that concession.
Ah,
Because there's some garment.
so, at least those cases we can,
this honorable court direction was to treat them as local and consider. Now we will consider, my lord, in the para 11. Just now I will report to your lordships.
you can tell us now. Yes, please.
Para 11,
End of the day.
para 11 peculiar to government.
Yes. So he will tell us. You should wait then. Don't leave the court hall. Sit here and be a part of audience.
In that case, lordship, even in the affidavit and also the additional affidavit, there is no the averment that she made.
Told her yesterday, but she
made an
sitting here didn't do anything.
she made an application on cap category for persons who
What
apply.
happened? She has passed which the,
Milord,
Lordship may kindly see.
1 minute, madam.
The person who seeks to claim under cap.
Unless you understand his objection, what will you appreciate? We have told you yesterday, day before yesterday also that amend your petition, you didn't do so.
I have done, Milord.
Blood under rule says.
What happened? She appeared in this thing, NEET, UG examination. Then what happened?
She qualified in the NEET.
Qualified. Then
Blood she claims blood.
applied for,
She claims admission under cap category. There is a 1% of seats are reserved on cap category. For to person eligible to be considered a cap category need to submit Milord the residency certificate of her father. The petitioner did not Milord the enclosed residency certificate.
so when she was required to submit, when she applied,
When the application for online applications are invited, she required to submit Milord the residency certificates of her parents, father.
did not submit along with application.
Yes, Lordship.
Then
But now the writ petition is filed seeking direction to the university to receive the residency certificate of
you
father.
received, Mr. and consider in second round of counseling because why?
Milord,
One minute.
No counseling is conducted for cap category. Cap category is the separate counseling will be conducted.
When?
Milord, after second phase or Milord, before the second phase.
So in the counseling for
For the
cap,
cap category has not been considered. Well, I
not held, therefore you will consider?
will consider Milord, subject to your lordship's direction.
We will direct.
Milord, then lordship may kindly see that the Sainik Welfare Department will consider her application and also the, under the rules, Milord, the application will be referred to the Sainik Welfare Board.
1 minute. She has got the residence certificate now.
She says, Milord, that she got.
43.
Milord.
Page 43.
certificate issued by the
Whether
MRO.
she falls, Milord, as a residency or whether she falls, Milord, under cap category or not.
That will be, therefore you will
examined by the
consider.
Sainik
At
Welfare
this-
Board.
At this point of
Subject
time,
to your
grievances
lordship's direction.
permit her. We will direct. So will
Milord,
you
then lordship may
permit
kindly
her
see.
or we should
that the
issue a direction?
Sainik- Lordship may give a direction to receive, but it's the exception, Milord. Tomorrow, number of cases will be filed.
No, what's
Because
the
they-
problem? Why she is ineligible to participate in the counseling for
Because
cap?
she did not enclose. Yeah, Milord, she
No,
did
so-
not enclose residency certificate.
Mr. Rao, what was the last date when she applied?
28th was the last date for submission of the residency certificate.
Madam, 28,
July.
12 dates
No,
in
sorry.
the year.
28th July 2023 was the last date, Milord.
Very, certain things are very clear to your
Sorry,
mind. We
Mr.
don't know. 28 July, again 23.
23 was the last date for submission. Milord, the petitioner could not get the residency certificate issued by the MRO by that time. So she requested through an email, requesting the respondent authorities.
Also,
to
they are
grant the
not
fund.
responsible, right?
No. She requested, Milord. Thereafter, 29th was the last date for the submission, Milord.
Issued on 31, sir. Tehsildar. Issued on 31, 7/22. And she applied when?
When did you apply for this certificate?
Applied on
See, if there is a delay in the government agency issuing, we can understand. You are not at fault. If you have not applied, then how can we consider?
Milord, I have applied on 28/7 only, Milord.
Same.
I have applied on 28/7. That they, even before that, actually, the petitioner's brother, he went, because the petitioner was staying in Jammu and Kashmir, the petitioner went to the MRO office to get the residency certificate of the petitioner.
Why she should have made it something like this? These people advocating top of their lungs and something that is the way, I'm sure I would trust you. If it's about right. Interim order. So who is at fault, madam?
Milord,
You argued like that day we were rising.
Milord,
And 19.8, you argued at the top of your voice that injustice is being
Milord,
done.
Milord, kindly refer
At
to paragraph
28
5 of the affidavit, Milord.
28 July was the last date. You applied on last day, got it 31st July.
Milord, kindly refer to the para 5 of the affidavit, Milord. Writ petition.
Mr. Rao, you consider, Mr. Rao, consider are in the round of, we are passing an order, not on your this, right?
As a special case, let me say,
Ah.
tomorrow, let this, it forms a precedent for a number of cases.
There's no other number and she won't file any other case.
See, Milord.
Huh?
I'm not filing any case.
Don't invite that I am getting an order today evening, come tomorrow, we will file another petition.
No, Milord, not,
Will be dismissed with costs.
not under the cap category.
So madam, never this thing, you are arguing as if some statutory right is being infracted without realizing the position under the rules that the counseling is separate round of counseling is held for cap category which is yet to be held. And you are not prepared to wait even on that Saturday. You are arguing from 4:45 and you made us write 1-page, 2-page order. This is all unreasonable to the court.
I'm sorry, Milord.
This is the order which you have argued at the top of your voice, and we had to pass an order saying that no, this thing counseling is being held. Yes. Mark the presence. With consent of the parties, the matter is heard finally. In this writ petition, comma, the petitioner inter alia seeks a direction to respondents to accept the residence certificate dated 31 residence certificate of the petitioner dated 31/7/2023 and to treat her as a candidate under the cap quota. What are children for and personnel quota for admission to NEET PG, NEET UG course, NEET UG course, paragraph. Facts giving rise to filing of this writ petition briefly stated are that
7. Milord, is page 31, Milord, our application.
Acha. Yes, madam. Last date 18/7 you have written, you alter it to 14/7. Previous paragraph 18/7.
For applying, total is 28/7. Total
Last-
28/7 only, no, Mr. Prabhakar. For registering, it is not up, registering with the university is 28/7. But along with the registration, they need to upload the certificate.
Yes, sir.
Because she did not get it, though she applied.
No, that's the case, but he is saying 14/7.
She made application 14/7.
She made application to the.
Page 31, Lord, please.
Last date was 28/7.
My lord, it is subject to correction, my lord, it is 29/7 at 4 p.m.
29.
Kindly refer to the.
See, Mr. Rao.
Line number 5 of my writ appeal. In the interim, she made it to university on the
Writ appeal, there is no writ appeal, it's a writ petition.
petition. In the interim, she made it to the university on 28th July.
30.
For the cutoff date.
Hmm,
Huh?
Of 4 p.m. on 29th July.
She is referring to data.
Page number 13. With the request to allow time till 1st August 2023.
Page 14.
The cutoff date in time was 29th July 2023 at 4 p.m. Because 29th was,
May kindly see page 46, Milord. My friend is not
Whatever.
correct saying page 46.
All right, so, we will not go into this. There's nothing.
Starts from 7/7, Milord, ends
Nothing,
6/7.
it's a peculiar, not a precedent. What considered submission, peruse the record. Admittedly, the petitioner had submitted an application seeking admission to MBBS course under cap quota before the cutoff date. However, the petitioner could not submit the residence certificate on or before last date of submission of such an application, that is
14/7.
14/7/2023, as the did not submit so and so, full stop. The petitioner, on account of circumstances beyond her control, was away from Hyderabad and would submit an application only on her return to Hyderabad on 28/7/2023. Thereupon, the Tehsildar has issued her a residence certificate on 21/7
31/7.
or 28/7 to sit down, madam. 28/7/2023. 28/7/2023. Full stop. The entitlement of the petitioner for consideration under the cap quota is under cap category is not in dispute, right? Whole thing is not in dispute, right? The counseling is scheduled to is yet to take place. Is counseling for admission to MBBS course under cap category has yet to has yet to take place, is
Yet to be noted.
yet to be notified.
Sir.
Therefore, in the peculiar facts of the case, we permit the petitioner peculiar facts of the case, taking into account the fact peculiar facts of the case, comma, the petitioner is permitted to, the respondents are directed to permit the petitioner to furnish her residency certificate. Needless,
Father.
Huh? Residency certificate of her father. The aforesaid, the respondent shall consider her candidature, petitioner's candidature under the cap code category. We hasten to add that this order shall not be treated as precedent, as the same has been passed in the peculiar facts of the case. Paragraph with the aforesaid directions, the petition stands disposed of, certified for. Madam, in the previous paragraphs you have read last date, etc. You write 14/7 there. 28/7 wherever you have written, you write 14/7. Petitioner applied on 14/7. That paragraph is correct, right? Last date 14/7. Disposed of. This is 52, right?
52 is okay.
No, this 51.
Item 51, Gopala. May I please?
What, Mr. Rao, you wanted to say in this case?
Lord, I have.
1 minute. Huh? Sit down, Mr. Yes, Mr. Rao.
Regulations, my lord.
No. So you said that she has qualified?
She has qualified, my lord, in unreserved category. Unreserved category, she was given admission in Mallarity College.
It survives for admission to Hyderabad. Not satisfied.
Not only fees common, if they get under related, it's common
Regulation.
regulation, but the thing is that.
There's some other college in not in Hyderabad.
Little away, but this is a
So,
major issue.
yes. So her grievance survives, right? She doesn't want to, she wants admission only in Gandhi Medical College, Hyderabad. So therefore, survives if otherwise if it is dismissed, then she takes admission wherever, right? But
Well, also pleased to direct Milan in 3 cases.
one
Treating them as a local candidate, university was directed to consider their cases. But on treating them as a local candidates, 3 candidates have got admission in various colleges. But Milord, in the presence, Milord, for 15% quota, Milord, they may get Milord in the.
yeah, no, Mr. Rao, in her case, 1908, there was a direction to treat her as local candidate.
Yes.
So have you treated her local
Local
candidate?
candidate, she was treated as a local candidate, her admission was given, but it was withheld.
Withheld. Admission, she is entitled to admission, which where?
Milord, in Karimnagar College, she got admission, but
Which college?
Karimnagar.
Karimnagar.
Chalimedam Anandarao Medical College. But the allotment was not given, Milord.
So if the petition succeeds, she will have to go to Karimnagar.
Yes, Lord.
Yes, madam.
One submission. Lord, just may pass on, Milord, the. Lord, the.
1 minute, we are just going through the long order which we have passed, so we refresh our memory. So, Mr. This thing Rao, in this case, since we have heard you at length in the previous bunch, your submission is, even though the petitioner was residing in the local area, but she has taken admission in a
Recognized institution.
recognized institution, therefore under that regulation she is not entitled.
She is not.
This is the case.
Yes.
Which regulation not entitled?
Blood, 4-1, blood, the.
4-1.
It's
No, not president, but
But-
for this rule you referred to rule.
Yes. That's why
Where is the rule? Which page? You must have filed the rule.
It's not filed, Milord.
The petitioner has not filed rules. You need to file. Where are the rules, madam?
See, Milord, the regulation.
Which paragraph?
21268, Milord. 21268. WP
Her case is 218893. You have not filed rules.
I have filed the prospectus, my lord, in the regulations are given, my lord. Same one, I am relying on the regulation. I have filed the prospectus, I have not filed the rules. 114 I have not filed, my lord.
One and four is there at page 68, madam.
Ah, 68, no, yes, 68. The order.
That's why kindly see, my lord, another repetition, my lord, first repetition. Of
Yes.
Manoj Reddy.
No, we will find out, but we are just trying to find out in these rules, it's not, in this, not there.
Page 18 of the, that thing. Manoj Reddy case, my lord, 2126, a senior counsel, my lord, Ramakrishna Reddy.
No one,
But
Ah, that is there.
in that, my lord, rule small a, small b, my lord, small. Rule 3, Roman 3, capital
Rule
B,
3, Roman 3,
capital B, small b.
she is claiming entitlement under which rule, Mr.? 342, 3.4.2 within bracket Roman 2.
The rules, my lord, it is rules, my lord, small b, capital B, rule 3, Roman 3.
Rule 3, number
Roman
3, rule 3, Roman 3, capital B,
Small b.
she is claiming entitled under this. Get that file.
I read.
Ah.
But at page 68.
1 minute, madam, you don't
Page-
annex the rules, what to do?
It is there,
And then-
page 68.
Where during the whole or any part of.
Madam, your paper
Contribute to
report is
academic.
incomplete. Please go to page 70, I will tell you. I did not want to tell you. Now please read. There is no B at all. Please read. Page 70.
Her petition is.
Please read, madam, your page 70. Look at the page 70. Where is capital B?
One line has. But I apologize, but by taking this missed.
This is what you are saying.
May I read, Lordship?
Ah,
Where during the whole or any part of the 4 consecutive academic years, ending with academic year in which he appeared, as the case may be first appeared, for the relevant qualifying examination, he has not studied in any education institution, if he has resided in the.
we remember.
That's all.
Yes, madam. Now, the only thing is, you are claiming entitled under rule 3BB.
Lord, I have prepared a synopsis of that facts of the case.
You are claiming, is it not correct that you are claiming under?
Yes, Lord, I am clear.
So where is that rule? Read it. His interpretation is that since you have, even though you have resided, but you are prosecuting a study course approved by government of Telangana, therefore you are not entitled.
Lord,
This is what has been argued.
yes,
What is your submission?
Lord, first my submission is, Lord.
Hey, madam,
Petitioner has continuously resided in Hyderabad. Facts is
that they are
Lord.
not disputing.
Yes, my lord, they are not disputing on the facts. Now, only thing is with regard to resident in the clause, regulation or the rule. My submission is the petitioner has resided in Hyderabad on account of COVID pandemic.
He is not disputing that you have resided.
Look, I'm coming to that, my lord. And during COVID pandemic, all over the country, my lord, all students were permitted to study online, my lord, and she has pursued. And now with regard to recognition, my lord, what is being submitted is not correct, my lord. Your lordship may kindly take first presidential order, my lord, which is at page, the counter they have filed, my lord. Your lordship may kindly take page.
I decided. That's what I'm saying. That's, I'm looking there. Whatever president has the petitioner school, she is prepared as. Studying, Mr. As she was studying in a course approved by the state government.
State government.
She was studying a course approved by the state government.
Yes, sir.
So you want the students not to prosecute any course and stay in Hyderabad and enjoy. If somebody studies online, no. You will not be treated as local.
Yeah, regulation says, my lord.
Fine. No. Mr. What can we say at 5 minutes past 4, after this 4:30? Yes. Yes, madam.
For my benefit, I will just read the provision once, my lord. Your
No,
lord,
madam, the problem is that we heard the other case for past 2 days. You were not there. So
I was-
we have no, that's why Mr. Rao could conclude in one sentence because he has already argued the point. We have repeated, we told you that this is the contention.
yes,
What you have to say?
I will satisfy your lord.
Mr. Rao, for our benefit and for our benefit, repeat your contention.
My lord, I get it, my lord. Your lordship may kindly give me.
No, if you have understood,
Yes, my lord. I have been here. I have been following the case since 2 days, my lord. I only make one submission, my lord. Recognition is concerned. It is only pertains to the first clause, my lord, not the second clause. It is not being read. Your lordship may kindly take the presidential order for a moment, my lord, which is at page 14 of the counter filed by them. If the lordship may kindly see. Your lordship,
So,
see
you are-
me, my lord,
no, madam.
relates to.
Let us understand because we granted interim order to you acting under some misconception. Because we thought that you are covered, your contention is you are covered under the rules.
Yes, my lord.
Because you are not, see, the fact is, but please listen. The fact is that you are not relying on the rule because you have not annexed that rule with the petition. So therefore, you are relying on a clause of presidential order to say that you are.
My lord, your lordship may kindly take the prospectus, my lord. I
What
wish the
Mr.
rules are there, my lord.
Lord, she does not come, Lord, within the definition
No,
of
no.
local candidate.
Mr. What we thought was that her cases she is covered under rule 3(3)(b).
Yes.
Yes, yes.
What? Yes, madam, without annexing the copy of the rule. You don't know when brother has put a query to you, then only you realize that it's not there. And you are jumping, yes. This is not the case. We will have to examine it in detail. So, Mr. Rao, what we thought was that it's under rule 3(3)(b).
No,
But it's not under.
Yes, yes.
Because she has not even annexed the rule.
yes.
Now let's see the prayer clause. What happens is we rely on councils when they argue. We should not.
But she did not challenge any rule, my lord.
Are not challenged.
That was my case also.
And rule also not annexed. So she is not relying on this rule 3. So what's your case, madam?
May I make one small submission?
Please.
The rules are in the prospectus. They form part of the prospectus, my lord. On the other day, when I made my submissions, my lord, I have read through the rules which are in the prospectus. The prospectus is at page, your lordship may kindly take it, my lord. The prospectus starts from page 33, my lord. The rules form part of this
Madam,
prospectus.
these rules you have
Yes, my lord.
annexed at page 68.
6. Those rules are given in the prospectus, the same rules.
Correct,
Yes,
Mr. Rao. 1 minute.
Prospectus, your lordship may kindly come to
1 minute. Mr. Rao, is it correct? 38.
Starts at 34.
I'll
No.
locally.
It starts at.
No, this is
In respect of what you know.
Eligibility page 36.
the condition for domicile. This is the conditions of prospectus.
No, it's not in the prospectus. The prospectus.
So then what is the difference between rule and the single?
Has to be 0, 117. So every year when they issue prospectus, they incorporate the same conditions. Instead of saying that they refer to the in the prospectus. And same thing, they have incorporated the draft to others. Okay. What they can say. But the no even in the prospectus law, not challenging.
Not telling me the reading, not relying on the reason.
Because we
Because
can
her eligibility is only professional to read from it.
because this refers to that's
An application for a claiming benefit of level 3 is the not. What will apply then?
prospectus will not have any legal sense.
Will be and should be valuing the petition and any benefit of the.
One second, madam. You need to amend your prayer, which is on. For the reason, please go to the same prospectus. Prospectus do not have any legal sanctity. Please go to page 36 and see the GO there, 114. So you will have to amend your 3.4.2 is nothing but same as clause
Yes, ma'am.
3.333 B, capital B,
Yes, ma'am.
correct?
Yes, ma'am.
So the challenge, if at all anything, should be to that. Because you are, if you see page 36, admission shall be in accordance with GO 114,
Yes,
correct?
yes,
So maybe they reproduce the same thing in clause 3.4.2 or 3.4.1.
yes,
But the authority flows from GO 114.
yes.
You will have to say that I am eligible in terms of GO 114. You will have to amend the prayer.
I'll make the amendment. I have mentioned in the prayer, as per the regulations, I am entitled to be considered under.
True, but if they are seeking to deny that regulation is coming from GO 114.
Yes. I'll make the amendment, madam.
Please do it.
Yes, madam. Learned counsel for the petitioner, after arguing the matter to some extent, submits that petitioner is entitled to be treated as local candidate in view of Rule 3, number 3, within bracket Roman capital 3, within bracket B, capital B, within bracket small b of what rules of Telangana? What rules?
114.
Rules, right? So and so rules. Just now it has been that other aspect. Which rules, Mr. Telangana?
Telangana, just read that.
Telangana
Medical and.
Telangana Medical and Dental College as
College
admission.
Admission within bracket, admission into MBBS and BDS courses, bracket close rules 2017. Mr. Prabhakar Rao, learned Mr. Standing Counsel for respondent, submit that even though the petitioner has resided in the local area for a continuous period of period of 7 academic years before the immediately before the immediately before the date of qualifying examination, give the rules. What is the expression? Yet she is not entitled to claim the benefit of the aforesaid rule, as she was studying course online which was approved by the state government. Paragraph, however, learned counsel for the petitioner prays for short accommodation to enable her to amend the writ petition. How much time?
Monday,
Prays for adjournment, prays for adjournment to enable her to move an application for amendment. List on. As prayed, list on. Monday is what date? 28th August. You give that, 1 minute, give that please for a reference so that exactly we may not be correct. One right, madam, Mr. Rao submitted that. The petitioner may have, that the petitioner has resided for 7 consecutive academic years in Hyderabad, ending with the academic year in which she appeared in relevant qualifying examination. However, as she has studied in an educational institution approved by the government, therefore she is not entitled to claim the benefit of this rule, then remaining order remains the same. Yes. CC quota. Please see what quota.
But I'm for the petitioner. And
Mr. Rao, ready?
I do not wish to detain my lords any further. Your lordship may take it up tomorrow. It's already
No,
4:45.
what is the, at least you can tell us what
Yes.
is the challenge,
Very broadly.
what rule?
My lord,
Yes.
an amendment to the rule providing for 1% reservation for NCC candidates. Doing away with the reservation altogether is under challenge, my lord, in the writ petition.
Weightage is given instead of you.
Now grace marks are given instead of percentage of.
Being given rather than a horizontal
Only
reservation.
only to some categories which were existing earlier. Large number of categories are existing, only 3 are
No,
given.
no, but this thing NCC candidates instead of quota are being given weightage.
Not all.
Grace marks were.
Only certain
Given.
Huh?
Lot of not bogus certificates have been generated. But therefore, we have the
So what NCC, some candidate, how many categories of NCC candidates are there? ABC we know.
ABC is there.
And
B is
any
provided.
other, and
Only B is
any
provided.
other category, only 3 categories.
Yes, only 3. And also, my lord, those who have participated in Republic Day parade, those who have participated, there are various categories, my lord. Mentioned.
No, so that's why we ask for our benefit.
Yes.
A, B, C category, then
Yes.
4th is 15th August and
Participation in
Republic Day.
Independence Day, Republic Day.
Participants in
Yes.
15th August, Republic Day, and what is 6th category?
And my lord, Sainik camp, those who have participated in Sainik camps.
Sainik camp.
Those who have
And-
obtained gold medals.
Gold medals.
All of them are done away with, my lord. Only 3 categories are given
So
now.
like 7 categories.
Yes, my lord. And those who are also,
So
my lord,
your grievance is that whom has been given weightage?
only B category.
B.
And those
So
who
you are A category.
I'm A category.
A category.
Yes, my
So
lord.
you are not concerned with others.
I'm not,
You only want that A category should get
that is all my case.
weightage.
No, my lord, we are saying restore the reservation,
Reservation.
remove the weightage.
So you are in fact a representative capacity for all.
I know, I seek only.
Just try to understand, we don't have the
I'll
right.
restrict.
Yes, ma'am.
Yes.
So like if the effect is that if petition is allowed, this thing, so all other candidates will be thankful to you for fighting the battle on their behalf and including them 26 January, 15th August and whatever.
But
Any
yes,
camp,
yes,
everybody will get 1% reservation.
yes,
See, Mr. Petitioner is so generous, Mr. Rao, you should emulate him. Not sacrificing his, this thing case for other category also, not saying that only B category. So you are challenging that rule.
yes, amendment to the rule is challenged.
but I'll
No,
file.
no, so 1 minute, the amendment to rule is struck down.
Yes, my lord.
Then what happens?
Then what happens is, my lord, I'm entitled under 1% wherever I stand.
No.
Yes,
So 1% is automatically restored, right?
yes,
That's the
yes,
position.
yes.
So it's a, this thing, what is substitution of the provision?
No, my lord, it's a case of deletion. The earlier provision is
Deletion.
deleted. They don't even say in so many terms, one of the grounds
No,
is
no.
ambiguity.
What we are just trying to broadly understand. So supposing if the provision which has been deleted is set aside as ultra virus
Yes,
example,
yes.
what is the effect?
Effect is, my lord, it gets restored status quo ante from the date the
I don't know. That's what will happen supposing if they you are saying a provision has been deleted by an amendment and we set aside that order after hearing all of you.
The amendment is set aside.
Huh?
The amendment is set aside.
Amendment
The
is
amendment is set aside. Challenge is to the amendment to the rule. If the amendment
amendment
is
by
set
which
aside,
it is some provision has been deleted.
if the amendment is set aside, the rule is restored.
He is saying no. What happens, Mr. Rao? So for what is your version? If the petition is allowed, what happens?
I am instructed to appeal. If it is,
No, we are not arguing. He is not arguing the case, right? We are just trying to understand, so that when they argue, you argue, we understand. So supposing if the petition is allowed, what happens?
I believe we have to go back to GMS 140. Where
Okay, so
reservation
the
Bureau of NCC
reservation
Right.
provision providing for reservation is restored, correct?
Yes, my lord.
He is not seeking and why we are asking repeatedly, because we cannot issue a direction to the legislature to provide reservation by amending the law. That was the anxiety,
Yes, that-
to understand that.
Whether a mandamus
That's in
can,
that context we are.
Yes, my lord.
whether a mandamus can be issued to directing the government to
Nothing.
provide reservation is a
Can't
question.
be done.
That's what.
He is agreeing, can't be done.
It can't be done.
That's
can't be
said
done.
law, will it?
Huh?
Law is settled on that.
Well
Well
said.
settled,
Law
no?
is settled on that.
At least we are happy that before argument of this case, both of you are on a
Yes.
same
it's a
page
little
that we can't be done on, so far as legal position is concerned.
Common ground.
It's a little peculiar case
A
why
very common ground to begin with, very good, right?
Yes.
Rarely it happens.
Yes.
a little peculiar case here in
No,
Malay.
no,
Central government has directed.
we will hear.
Yes.
This he has to argue, so the effect of supposing if that amendment is struck down, there is already a provision which gives him the benefit. So we have to confine ourselves
Yeah.
to only whether that provision is what they have power. It's
Yes.
the only thing is arbitrary.
But I have
What's
raised
the
several-
possible point? Unequals are sought to be treated as whatever
But
equals. of
Article
each
Article
other.
14 arbitrariness.
I like that, sir. Yes.
I will support.
Yes. So. Which is the provision?
Legal actions part.
Which is the provision amendment? Just
Now,
towards the
Roman 4 method is amended.
page.
Yes.
Let's see. No, we are not asking you to begin, right? Just provisions. Just, yes.
That's what-
This only provision we want to see. What is it?
The provision is at page, it begins at 38.
Hmm?
It begins at 38. Kindly go to page 42. ma'am.
38 is Aadhaar card.
42, page 42.
38 is Aadhaar card.
Page 42, Miller. My lords are taking item 54, Miller. I am
It's 53.
54. I'm sorry, Miller. 53 council says,
The
Miller.
council has gone home,
He says,
relying on you.
Milord, sir,
See how
We are-
tremendous confidence people have in your skills.
he said so and went away, Miller.
We are sailing with them, Millards. That's the reason why.
Ah.
Let them argue first, Millards. After that, we will be arguing, Millards.
No, nothing arguing. After senior council argues, what is that?
Very well.
You will adopt, but you must know what has been argued to adopt.
Yes.
One thing, just like a council like you, huh? The senior council, the council finished the argument and he said, I adopt. And he had just walked in. That argument was going for 1.5 hours. And the council like you just walked in and sat down 2 minutes and said, I adopt. So the bench headed by the chief justice asked what they have argued. You must know. You must know before adoption. So don't be in that position, right? Be there when he argues.
Page 42, Miller.
42.
Roman 4. Roman 4. C is deleted.
National.
Hmm.
You will apprise us about the scope of judicial review in such a case,
That is that.
doing away with horizontal reservation.
Yes, that is a point involved in this one.
Everything we say, you say point involved.
Yes.
You tell us what is the point involved first.
Well, I said,
Huh? What?
when my turn comes, by that time means we are running with.
No, you are saying whatever we say, you are saying this is the point involved. So therefore we ask you, what is the point involved?
Point involved is whether mandamus can be issued is the enabling provision. Stay. Under Article
He is not
16.4
seeking
or
a-
15.4 is the enabling provision.
Arey, Mister, he is not seeking a mandamus, he clarified, right? You started off a common this thing around.
So Rashekar, please look at page 17 of GO 75
Yes.
under the note. First point of the note.
18674, right? Your WP.
Mine is that.
Ah.
Please
Page-
see 17, page 17,
My lords are referring to the latest 75 or the earlier 75.
that is the 8/9/2015.
Yes, that is the one which provided for reservation.
Now the subsequent thing, they are
Now,
only
my lord,
giving
the latest one which is challenged is at page 19.
19, yes. In this, they are giving 7 for. it
What is
not
that?
Everybody is being treated the same. Even here, they are giving weightage based on the, your
Page 21, my lord, is the
21.
amendment.
NCC, if you have participated in RD, Republic Day Parade, RD, then it is 7%. Then if it is Sainik Camp, it is 5%. Other NCC B certificate is 3%.
A is left out. A is left out.
Okay, we continue tomorrow.
Very well.
Tomorrow. No other cases.
Subject.
Lunch motion is closed.
Your lordships, they are also with respect to the medical admissions, your lordships. However-
It's lunch motion.
Lunch motion.
List along with Madam lunch motion, list along with
the issue,
WP
your lordship-
number 81.
Your lordships, these,
85.
Your lordships, in these
One- 1 minute. Item number
83, your lordships.
83. A list along with WP number 18047/23.
Or maybe your lordships, the matters may be taken up as fresh matters tomorrow because your lordships have sought for a separate interim order. Because your lordships, with respect to the second council, in fact, your lordships, the 83 batch that is dealt with in relation to the first council. My interim application is separate, your lordships. In fact,
You said that it is linked and all that.
on question of law, it is linked, your lordships. However, I've sought for a separate interim order. The issue,
But interim
interim order-
relief is interim relief.
interim relief is separate, your lordships.
See, why, if we supposing grant interim relief, you can go to Delhi. If you doesn't grant interim relief, we can go to Delhi. In a case where we had not said anything about interim relief, the council went to Delhi and you know what happened in that case. Came back. So he wants to go to Delhi.
It's not
Weather
about-
appears to be good right in
I'm just
Delhi.
being hopeful that I might get the interim order, considering I'm only
Hey,
seeking
Mr.
a direction and not a suspension.
Since you have appeared before us, I hope that you knew the bench, right?
Absolutely,
That
Your
at 2 o'clock, what can we?
Absolutely. Tomorrow, Your Honor. I'm only requesting that they may be taken
Alright,
as fresh
Mr. Rao.
matters tomorrow.
Lunch motions, item 1 and 2. List tomorrow. 9?
9 matters, Your Lordship.
You said 1, you said 2 cases and then got listed 9.
I gave the slip for 9 matters, Your Lordship. I-
Is there an interim order in other cases? 81 matters, 83.
83, Your Lordships, there is an interim order where the
Subject to hearing, list tomorrow, madam, 9.
as fresh matters.
Subject to lordship's pleasure, my lord. Lordship's pleasure.
Obviously, has it been admitted? Then how it will not be treated as fresh? It will be list, it will come up for admission only.
Subject to lordship's pleasure, my lord, I may permitted to make a mention in respect of one matter, item number 109 to 113, where the transfer of the teachers
It's
by
continuing, Mr. List. We are not adjourning. What do you think?
my lord, two
This is
thirty.
like these students have left us today. So now after we are looking for other still student, he is not
Yes.
leaving us. So you talk to him, teacher recruitment batch, whether he wants to argue, whether he will permit.
Because entire state administration, just I'm.
No, no.
Difficulties of the state, I'm bringing to your lordship's notice, my
No,
lord.
no, Mr. You should mention at 10:30, 2:30, whatever.
I
And
was-
it's not being adjourned. It will come up
I was
tomorrow.
under the impression that your lordship would reach today, my lord. Tomorrow at 2:30, my lord, your lordship may kindly say. The entire department is looking at your lordship, my lord. 860,000 teachers are looking at
One
your
minute.
lordship. I'm sorry, I'm sorry.
You haven't told except for entire state and looking, they should look at father of the nation, how he used to live. What, this is such a beautiful portrait. They should look at this. And it's any case live stream, we will ask them to focus on that beautiful this thing. At 5 o'clock, Mr. You expect us to take up the case? Go
Tomorrow at
ahead.
10:30. Tomorrow at 2:30, my lord, this matter may be taken. In
What is the
otherwise, I will
urgency?
not trouble your lordship. my
What
lord.
is the urgency?
Urgency, my lord, the transfers of the teachers had been come to a grinding halt from 14th February 2020.
This again, Mr. Somebody had made a mention in the morning. Are you aware?
Yes, my lord, they are also trying.
No, no, no.
Special government leader, Mr.
Sit down,
Santosh
madam.
made a mention.
Santosh.
Special government leader attached to the office of Advocate General, Mr. Santosh had made a mention. We asked him about the facts. Then Santosh. Santosh, Mr. Santosh had appeared in this matter, saying that it is teachers transfer and all. So we said we have a priority for the students. That is why we will not take it up. That is what we indicated to him.
It's continuing in the list. The moment it is over, Mr. You be brief, right? Huh? You must give way to teachers transfer.
Yes,
It's a big industry, right?
Yes, yes, my lord.
We can appreciate their anxiety.
My friend also has to be brief.
Even if you give admission, there will not be teachers.
There will be. So how much time will you take tomorrow?
I won't take more than 30 minutes.
Conclude in 20 minutes.
Very well. I'll
Yes.
do my best.
We appreciate,
Yes,
we
ma'am.
understand what is all
Yes,
the
yes.
point. And Mr. Rao, as usual, he will be very brief. Mr. Rao, correct? You have filed counter, etc., right? It's being heard. But why should we hear you finally?
To your lordship, there is an interim order, they have not complied with it. To accept my application, they have not complied with it.
Because Mr. Rao, you will appreciate that every case we cannot go on hearing finally. Right? Will you
In
appreciate?
fact, this case is posted to 29th. my lord. He made a
One
mention.
minute.
Yes.
So have you complied or have you filed vacation?
We filed an application to vacate
Yeah.
and where the NCC admission to NCC special categories has not yet taken up. Not yet taken up. The question of consideration doesn't arise. We have filed a contempt case against us even before considering. The occasion has not arisen for consideration. We filed a contempt case.
Now we will modify that order. Don't, Mr. As and when it is notified, as and when it is round of counseling is notified for NCC candidate, then you can make a prayer. But there are some other cases, right?
My lord, it is he who is pressing for hearing. I am not, my lord.
No.
Yes.
But he has filed an application seeking modification of stay, and why he is pressing is
Yes.
that you are threatening him with contempt, where he will go.
My lord, your lordship may.
No,
refer me undertake.
that's what you did not hear Mr. Rao saying
heard
that.
it.
Yeah, 1 minute. You did not hear Mr. Rao saying that There's no question of compliance because that schedule of counseling for NCC candidate has not been notified.
When the
How they will consider?
When the time comes, let him. When the time comes, let him. No, I will
So
not press
therefore
the contempt.
contempt,
I will not
we
press
will,
that. Your
it is our duty to protect him from
Your
contempt.
lordship may record, I will not press the contempt. Let him consider when the time comes. That's all I am saying. Yeah, let him
Give that
record his undertaking also.
NCC.
Item 54, my lord.
Ray, you should have said, Mr. Rao, in the beginning that this is what at least be clarified. We would have done it, not repeated
Yes,
tomorrow.
in fact, yes.
We have to permit the industry to flourish, right? Additional AG. Transfer industry should flourish, right? Huh? Yeah. See, 10/8/23. See, after 3 weeks. 3 weeks. 3 weeks is not over. Status from the seeking that. Where is the interim order, Mr.?
Page 9, my lord.
Of vacate petition? Page 9. Not there.
18674. 186.
18674. We have got 18674.
That's why see the interim order.
Counter. No, date of order, interim order when?
Date of order is 14 July 2023, man. It is
That
at,
is the date, that's the
before-
last date of application.
it is at page 7.
1 minute.
Yes.
So, admission to first year course by tweaking NCC A category candidate. Your
Yeah.
application,
Yeah,
1 minute. Their application has been entertained.
entertained.
Hmm.
But consideration to A category does not arise in view of amendment to the rules.
That is the issue, but despite that, the interim order has been passed, right? All right. Mark the presence. In this writ petition, we will modify the interim order to save you from clutches of contempt.
Your lordship may also
No.
kindly consider directing them to, may not consider whenever the situation arises.
No, you let them file counter everything. We will hear it.
Sir, on
We
record.
will hear it.
I am ready.
Not tomorrow.
Very well. Whenever my
We'll
lord.
hear it whenever you please mention the matter that or this thing that schedule of admission is going to be notified or notified, we will hear.
Your lordship may kindly record his submission that they are not notifying this category. That's all what I wanted to say.
Not notified as
Yes,
on
he
today.
said so right now. Kindly record his submission.
Yes, definitely. Yes. In this writ petition, comma. Mr. You must sometime, please take some time. You are all are very busy councils, but we have go through the prayer clauses in the petitions and find it very like all of you have not read. It gives an impression that none of you have read the law of writs. You are saying mandamus seeking insertion of clause so and so arbitrary, illegal.
Yes, my lord. Very well.
Mandamus can't be there. We have to rephrase so as to this prayer clause should be, otherwise we will be, anybody can say, see what High Court is writing. It doesn't know scope of writ petition, a writ of mandamus. What, mister? At least read it. I mean, we know that this all, it must be fed in the computer and thereafter second line you start typing or somebody this thing starts typing.
Very well, my lord. I will,
Please go through it before signing.
I will do that.
In this writ petition, comma, the petitioner has assailed the validity of amendment made by insertion of clause 3, Roman small 3 within bracket A within bracket small a of Telangana, A in rule 4 of Telangana Medical and Dental Colleges admission within bracket admission in MBBS and BDS courses bracket close rules 2017 17 full stop, by which the provision prescribing for reservation of to horizontal reservation of seats to MBBS course to the extent of 1% has been deleted. Paragraph. A bench of this court by an order dated 14/7/2023 had directed the university to entertain the application of the petitioner for admission to first year MBBS course by treating the petitioner as NCC A category candidate. However, it was also made clear that the admission of the petitioner will be subject to further orders. Paragraph. Learned counsel for the standing counsel for the university, while inviting the attention of this court to averments contained in the vacate stay petition, has submitted that in compliance of order dated 14/7/2023, the university has treated the petitioner as NCC A category candidate. Since it is further submitted that since that separate counseling is required to be held for admission to in respect of NCC seat, since the aforesaid schedule of since the date of counseling has not been notified till today, therefore it is not possible for the petitioner for the university to admit the petitioner under petitioner who belongs to NCC category candidate at this point of time in the face of the rule which is impugned in this petition. It is further submitted that the interim order be modified as suitably modified as the petitioner has filed a contempt petition against the against the officers of the respondent university. Paragraph. What do you submit?
But I just wanted to say that, let them
The
consider
learned
whenever.
counsel for petitioner has opposed the prayer made on behalf of learned counsel for the university. Paragraph. We have considered the submission made by learned counsel for the parties. The university has already entertained the application for petitioner, entertained the petitioner for admission to MBBS course by treating the petitioner as NCC A category candidate in compliance of the order passed by a bench of this court. However, the question of admitting the petitioner to the MBBS course at this point of time does not arise as the counseling has not been notified. Counseling for admission to against MBBS seats has not been notified. Therefore, the interim order dated 14/7/2013 insofar as it directs admission of the petitioner to this court is modified, and it is submitted that as and when submitted that the petitioner shall be at liberty to approach this court with regard to his grievance for provisional admission, and as and when schedule as when and date for counseling in respect of NCC
Let them
seat
consider-
is modified. A is notified. Accordingly, IA number so and so is disposed of. Correct.
Whenever
You
my lord,
file
they are
counter.
considering case. Counter is filed. my lord.
You have filed.
Yes, my lord. Counter is
The
filed.
petition is admitted for hearing.
My lords may kindly consider directing them to, my lord, whenever they are undertaking, let them consider the case
54.
of
54, 55 same order, 56 same order.
53, my lord.
56, not,
1 minute.
I made an IA for amendment of prayer.
56, for amendment.
So the same order which has been passed in his case.
56, not, I find I
Amendment. Yes, Mr. Prabhakar. Allowed. 56 taking in what?
amendment of the main prayer.
No. What is the prayer?
I had earlier not challenged.
Heard on IA number 2 of 2023, Learned Counsel 56, madam. Learned Counsel for the petitioner submits that inadvertently he had not assailed the validity of the aforesaid rule. By the proposed amendment, he wants to challenge the impugned rule. So and so, whatever rule previous case we have written. The aforesaid prayer is fairly not opposed by Learned Counsel for University, taking into account the averments made in the petition, as well as for the reasons assigned so and so, the IA is allowed. Let amendment, let office is direct. He will inform.
File a fresh amended.
Fresh amended petitioner shall incorporate the amendment and file a fresh petition, amended petition.
But NCC has to file counter, my lord. NCC has not yet filed its counter, counter not to.
With how much time?
It's not done.
2 weeks, huh? Then previous case also, counsel, Mr. Praveen Kumar.
None of the cases. are-
DSGI. Praise for and is granted 2 weeks time to enable him to file count. Fine. So if this takes
Right.
care of this thing. Up to, so no other case, madam?
Right.
Only that bunch comes. Now, why you should be heard, Mr. There is an interim order, right?
In the batch from 83 to 86, your lordships, there is an interim order.
Ah.
These are fresh matters, your lordships.
So
where I'm-
let's see what we are sitting here, Mr. Rao.
Kindly see, Lord,
No, no. So you have got the notice or you want to argue it tomorrow?
I want to argue tomorrow.
Tomorrow, fine.
There are also these same from 8 to 17.
8 to 17 are similar matters.
identical to the lunch motions.
or 7 to.
There are similar matters.
7 to 17.
7 to 18, your lordships, they are also for the,
1 minute.
Lord, 83.
Issue in 7 to 17, there is an interim order.
no, your lordship.
No, it's-
They are also fresh matters.
They are all fresh matters which have come.
There is no interim order. Those, they were direct plus 7 to
So
17.
it was called, no, 7 to
Yes,
17,
your
you
lordship.
said.
I was under the impression that 81 would reach your lordship. My sincere apologies. They may also be taken up tomorrow, your lordships. I am only arguing for IA.
Ah, IA, you should argue only for IA.
Obviously,
Because it's,
absolutely.
there is always a limitation. We are also human beings, right? Every case, there is an interim order. We cannot keep on hearing every day till 5:15.
I will not take more than 5 minutes.
5 minutes to argue interim relief only. You get interim relief or go to Delhi. These are the two possible scenarios. Or Mr. Rao goes. He doesn't want to go to Delhi.
Neither do I want.
Huh?
Neither do I.
You also don't want. Okay, good, good.
I'm being hopeful, your lordship.
No, but Delhi is a good place, right? You should go. Okay, we'll see tomorrow.
Obliged, lord.